Hello students, this is Professor McDonald. This is a discussion that I wanted to include in your course materials relative to the Foreign Intelligence Surveillance Act. In particular, this relates to Chapter 4, and I'll post this as a YouTube resource. This particular chapter is complex, it's long, and a lot of the discussions are about FISA, or the Foreign Intelligence Surveillance Act. So what I wanted to do was just talk about it a little bit, and hopefully it'll help some of you understand what the focus of our authors is in this particular chapter. Now, just when you talk about surveillance, what is surveillance? It's an observation of someone or something. You do this frequently in law enforcement. And intelligence itself, what is intelligence? It's not the same as our textbook describes as evidence, but intelligence is gathering information. For example, foreign intelligence on a foreign power who may be trying to spy on the United States. And so when we talk about the Foreign Intelligence Surveillance Act, those are two key issues that I'll address. So let's look at the legal posturing in the United States prior to the passing of the 1978 Foreign Intelligence Surveillance Act. Up until the Katz decision, which is discussed in the book Katz versus United States, where the FBI had conducted an electronic surveillance eavesdropping on Mr. Katz without a warrant. Up until that time in the United States, it was routine for government agencies that were involved in law enforcement and intelligence to conduct warrantless recordings or electronic surveillance activities. In other words, they weren't going to a judge to get a warrant before they would actually eavesdrop and record the conversations of individuals. Katz changed that. The Katz decision, which occurred in 1967, was a landmark Supreme Court decision, which basically said that the Fourth Amendment protects people, not places, and that if the government is going to conduct electronic eavesdropping of an American citizen who is a target, then they need to have a warrant before they do that. What ultimately also happened in the 1960s, there was a lot of warrantless eavesdropping that was occurring within the United States, in particular on targets that were within the civil rights movement, targets in groups like the New Black Panther Party and other civil unrest organizations, and even organizations that, like the CIA, that actually have no jurisdiction within the jurisdictional limits of the United States were involved in some of these surveillances. So what happened is, as information was released to the public that this type of collection of intelligence was ongoing, created quite a political stir within the country. So what emerged eventually was congressional action. In particular, the Church Committee was a Senate committee that conducted hearings on illegal wiretapping and trying to put together a report as to how this problem could be addressed. Now, another thing that occurred after the Katz decision, and this was in response to Katz, was the Title III Omnibus Crime Control and Safe Streets Act of 1968. Among other things, what it did was it prohibits electronic eavesdropping and requires law enforcement to get a court order if you engage in such surveillance. So this was a response to the Katz decision. So let's go back to the Church Committee real quick. So this committee went on for a period of time. There were other decisions that also occurred. United States versus U.S. District Court, which is called the Keith decision in 1972, basically advised that the government needs a warrant to perform electronic surveillance relative to domestic security issues. So these things were leading up to what ultimately transpired in 1978, which was the passage of the Foreign Intelligence Surveillance Act. In their findings, again, the Church Committee exposed the unlawful secret surveillance of American citizens who posed no threat to the government. Even individuals like Martin Luther King had been surveilled electronically. So in 1978, Congress passed the Foreign Intelligence Surveillance Act. It was created to provide legislative authorization and regulation for all domestic electronic surveillance for foreign intelligence purposes. And so let's talk about that a little bit more. Now, the Congress took into account that foreign intelligence or national security investigations are very difficult investigations to conduct. And why is that? Because when you're investigating, let's say back in those days, the Soviet Union, in your counterintelligence activities, what you're trying to do is identify and uncover Soviet spies that are here in the United States trying to collect our national security information. And so it is our job, in particular the FBI's job, to identify those spies and counter their efforts. The Soviet spies, just like spies from China, North Korea, or any other, these people are highly trained individuals, just like our spies that we send overseas. And so these are difficult cases to work because you're dealing with individuals that are very well trained in the trade craft and to avoid detection and that sort of thing. And so they understood that. They also understood in the legislation that the secrecy, when we're talking about intelligence gathering, we're talking about secrecy and methods. It's very important to retain and protect those methods of collection so the other side doesn't know how you operate. Again, what I'm talking about is foreign intelligence surveillance. That's what FISA is about. Now, what FISA did was it also created the FISC, or the Foreign Intelligence Surveillance Court. And so after the act was passed in 1978, if the FBI wished to conduct foreign intelligence surveillance using electronic surveillance methods, they would have to get a court order to acquire the contents of any communications if it was possible that any American citizens or lawful aliens that were admitted to this country for future permanent residence, or anyone that's associated with American corporations, etc. In other words, if any of those people possibly, if their communications would come up and possibly be collected during the course of this electronic surveillance, then they need a court order. That is issued by the Foreign Intelligence Surveillance Court. And there's a whole process they have to go through. It's very difficult. But the FBI would have to go to their liaison person. That person goes to the Department of Justice. The Attorney General's office has to certify it. Then it goes over to the court. There's a very good film that I'm requiring you to watch where you actually have a former FISC judge who does a presentation on this particular subject matter. Now, let's go back to what we're talking about. So if there's a likelihood that an American could come up on the interception or the eavesdropping, then you got to have the court order. If you can convince the Attorney General that there is no chance that an American citizen would be intercepted during the activity, then you do not have to have a court order. So if the only person that you're going to capture, the only communication you're going to capture, and you can certify that, is it's going to be a foreign national, say a spy for the Soviet Union or Russia or China, then you do not have to have a court order. But if there's any chance an American is going to be captured in this surveillance, then you have to go to the court and get a court order. Again, the Attorney General has to approve it. Now, in applying for the court order, you must fully identify the target, the basis for believing the target is a foreign power or agent thereof, the information sought, the means of how the surveillance will be conducted. In other words, are we going to do an eavesdrop? Are we going to do an interception through the wire? Are we going to record, link into their telephone communications, intercept the cell phone calls? The minimization procedures to be employed. In other words, whenever you engage in this type of activity, you have to minimize the FBI, but let's say it's an FBI case, they have to minimize the likelihood that an innocent American citizen will be captured in this interception or this surveillance. The time period of certification of the NSA or the National Security Advisor, that information sought is a foreign power information and it cannot be gained by normal investigative procedures. In other words, there's no other way to acquire this information. Okay? Now, FISA, what I've mentioned so far is foreign powers, and what we're talking about would be like spies for Russia, North Korea, Cuba. But this also includes groups that are engaged in international terrorism, which could be an Al-Qaeda Islamic State. It's important to remember that when getting this court order, it's not like a standard court order you would get in a criminal case. The probable cause standard is different, and that's explained fully in the book. I'm not going to repeat it. Basically, what you have to do is just prove that this person is a foreign power or works for a foreign government. You don't have to prove that the information is going to lead to any particular crime or you have evidence of such a crime. And FISA can authorize not only electronic interception of communications but also physical searches. There are time periods that are placed on FISA orders. FISA targets, unlike a normal electronic surveillance or the execution of a search warrant in a criminal investigation, you have to notify the target that you have searched or you have conducted such a interception. Under a FISA warrant, you do not have to notify that person. Now that makes sense, especially if you're working a case on terrorists or a case on a international spy. You're not going to notify them that you're looking at them because they'll disappear or they'll start using methods that will make it much more difficult for the government to make a case. There are emergency situation clauses where if something pops up suddenly and you don't have time to get a court order, that you can, for a short period of time, go ahead and initiate the surveillance, but you have to follow that up with an application for an order. Now, the Foreign Intelligence Surveillance Act court, there's actually a court, and there's actually a review court as well. The Chief Justice of the Supreme Court, he appoints the Chief FISA judge. There are 11 district court judges. These are federal trial judges that serve at one time on the FISA court. 3 must be, I think it's within 20 miles of the District of Columbia at all times. And again, the FISA warrant only requires the target is an agent of a foreign power or international terrorist. That's what you have to show. That's your probable cause standard. I put a chart in there in the slides. The vast majority of FISA orders, which have greatly increased since 9/11, obviously, are approved. And that's one of the, they talk about in the book, that's one of the complaints, that it's like a process that just gets whitewashed, and since they rarely turn anything down, the opponents of the FISA process say that anybody can get a FISA order because they never turn them down. That's one of the complaints against the entire process. There's some interesting discussion in the book about the FISA administrative law that occurred. Because FISA, and this occurred in the 90s, the Department of Justice put a memorandum out to those individuals that were working national security cases that they could not share any information that they obtained during the course of their investigations with the criminal side. somebody that's working on the criminal side. So if you were an FBI agent working national security, counterintelligence, and you developed information that could maybe be used as to help one of your colleagues who worked criminal investigations, you were not allowed to share that. And the justification that the Department of Justice used was because the probable cause standards are different in a criminal case versus a national security case with a FISA court order, that would taint the process and the evidence would probably be excluded anyway. So what was the result of that? But the result was that criminal investigators and prosecutors and foreign intelligence agents could not share information. So as a result, the flow of information was not very good. And some of this impacted, as our textbook talks about, it had a negative impact on 9/11 because there was information out there that may have, like with the 20th hijacker Moussaoui, where they tried to get a search warrant for his computer, that was rejected. So some of the criminal people were developing information, some of the intelligence people from different agencies had information, but because of some of these administrative barriers, and also turf wars between agencies, nobody was properly sharing that information, and so the dots could not be collected or connected. Now, after 9/11, we had the passage of the Patriot Act, which also impacted FISA. And it expanded some of the powers. It broke down that administrative wall that I just previously talked about, so the intel people and the criminal people could share information, and it forced agencies to work together through strategies such as the creation of the National Counterterrorism Center, which I've talked to some of you about in prior classes. And that is a center where all intelligence groups sit under the same roof and they share information. Patriot Act also allowed for sneak and peek warrants. And what that means is you can actually, on a national security case, targeting a spy or targeting an international terrorist, you can actually, if you can identify their residence, agents are allowed, when nobody's home, to sneak in there and look around, see what they see. And obviously plant some bugs, some electronic listening devices while they're in there. So these are some of the things that the Patriot Act did to enhance and impact FISA. And there were other things they taught. It actually increased the Foreign Intelligence Surveillance Court from 7 judges to 11. Nationwide execution of warrants in domestic and international terrorism cases. In other words, if I get a warrant on a suspected terrorist and I get it in the Eastern Virginia district, and that terrorist travels to California, I do not have to go to California and get a separate warrant. That warrant would cover me anywhere in the United States. And that's just kind of a common sense approach thing, simply. And also due to the fact that terrorists and criminals, they go through phones very quickly. And they buy these throwaways that are difficult to trace. So it's impractical for agents to have to get a separate warrant for every different phone, and also for individuals that are constantly moving from state to state. Let me wrap this up relatively, because I've talked long enough here. FISA also had some amendments. Of course, it was amended with the Patriot Act, and there's some sunset provisions where Congress can come back and review those provisions, which they've normally approved again for, 3 to 5 years. Then they'll review it again. But some of the things that they have adapted to, in 2004, they added the lone wolf international terrorist as a non-United States person who perpetrates or plans international terrorist activity. This is a person that they can target. Also, you see with the 2008 FISA amendment, the amendments with the passage of the 2008 update to FISA, you saw some other things that occurred. And some of these involve mass surveillance programs. And basically, with the 2008 update, it took an approach to limit warrantless surveillance to persons located abroad. So again, we're talking warrantless now. We're talking about where they actually don't have to get a court order, and that is authorized if, in compliance with this law, would be that you cannot target any person known to be in the U.S., so they have to be overseas. Cannot engage in reverse targeting. In other words, you say it's a person overseas, but you know you're trying to track it back to a person in the U.S. Again, this goes back to the foundation of FISA, which was to eliminate and reduce the amount of American citizens that are being electronically surveilled absent a search warrant or a court order. You cannot intentionally target a U.S. person located outside the U.S., cannot acquire communications of parties known to be in the U.S. at the time of acquisition, and these activities have to be conducted consistent with the Fourth Amendment. The textbook identifies some of the other procedures, but FISA is a very strong statute relative to countering the threat from terrorism, but also protecting our national security interests. There's a lot of additional information in the textbook about this. They go into the weeds a little bit more, which I want you to read. But I just wanted to give you some general overview of the statute itself and what it intends to accomplish. That'll be the end of this dictation.